U.S. regulation of lawyers and the legal profession. Perhaps the world's most highly regulated profession, U.S. attorneys are subject to regulation from various bodies, including the Model Rules of Professional Conduct, the Code of Professional Responsibility, and the Model Code of Judicial Conduct from the American Bar Association, the Restatement Third, the Law Governing Lawyers from the American Law Institute, the Rules of Professional Conduct from the State Bar, Business and Professions Codes from the State Legislature, the State Supreme Court, Federal and State Evidence Codes, especially rules on confidentiality, and ultimately some disputes over the regulation of lawyers are settled by the U.S. Supreme Court. The basic rules are as follows. A lawyer must be licensed in a state to provide legal services in that state. Temporary pro hac vice and other exceptions are sometimes available for out-of-state licensed attorneys. The solicitation of clients is prohibited, but advertising to the public is now okay, and general legal referral services are okay. Lawyers only are allowed as partners in law firms. A lawyer cannot partner with or share fees with a non-lawyer when practicing law. The attorney-client privilege and the ethical duty of confidentiality require the attorney to keep client confidences. Ultimately, protection of the client is usually the goal of all this regulation. To minimize liability exposure and create a liability shield protecting the owner from creditors, an individual setting up a new business will often choose to organize as a corporation or an LLC, a limited liability company. However, these business organizations are not available to law firms. When it comes to forming a law firm, regulators are concerned that the firm is owned only by lawyers and that the liability shield does not entirely protect the lawyers from claims of malpractice. Malpractice claims are thought to provide some protection for clients and a check on the misconduct of attorneys. A law firm is able to operate as a sole proprietorship, a partnership, or a limited partnership, structures that don't provide extensive liability protection. Other special forms of corporations and LLCs are available for law firms, including the professional corporation and the professional LLC. Liability can be mitigated in these structures, but the lawyers remain answerable for claims of malpractice. U.S. regulation of lawyers and the legal profession.